Hey y'all, Rob here with ATX Legal, and today I'm going to be talking about parole eligibility. It's actually the first of a three-part series on parole. I'm also going to be discussing the parole hearing process, and then lastly, the revocation process if you do end up getting revoked on parole. So if you're interested in those topics, go ahead and find those videos or subscribe, and you'll get those videos when they come out. And parole can be a tricky topic, even for experienced criminal defense attorneys. It can be kind of a black box. And by that, I mean the Pardons and Parole Board can kind of do what they want without very much court oversight. They can make decisions without attorneys present, and it can get really messy really quickly. And there are a lot of caveats, a lot of little tricks that if you miss that in the code, your calculations are gonna be way off. So you just have to be very careful. It is very important to get an experienced attorney who knows about parole to help you with your case. A lot of people who calculate their own parole eligibility dates and that kind of thing, they either don't understand what those dates mean or they calculate them wrong because of all these little rules that kind of change and tweak what those dates are going to be. And the first thing I want to drill down on is that word eligibility. Some people hear parole eligibility and they focus on that parole and they don't think about the word eligible because it doesn't mean you're necessarily going to be released. It just means that you're eligible to be released. You'll still have to go through that hearing process. And statistically, about 1 in 3 people do actually get released from parole. So still not great odds, 1 out of 3. So you can't be thinking, oh, that's my release date. And a lot of people do. And of course, the specific factors of your case can change those odds. It's not 1 out of 3 for everybody. Factors like the type of offense you're charged with, whether there's a statement from the alleged victim, how your behavior has been in jail, all these factors add together to change the odds in your case. So it's not 1 in 3 for everybody, but overall 1 out of 3 people are released. Now, another caveat is we're talking about first, second, and third degree felonies. We are not talking about state jail felonies. Those are handled with what's called diligent participation credits, where you can get up to 20% of your sentence knocked off. However, that's not parole, and a lot of people think they're getting those diligent participation credits when they're not. You don't get any of them while you're awaiting trial. You have to be actually at the state jail. So a lot of people are counting on those 20% diligent participation credits and they don't get them. Be sure to talk to your attorney if you're counting on those. Also, parole doesn't apply to misdemeanors. Usually with misdemeanors, you're getting 2-for-1 days in jail, meaning if you sign up for a 1-year sentence, you would do 6 months and that would count as the full year, or even 3-for-1 if you're given what's called trustee status, given a job in the jail, that kind of thing. You can get up to 3-for-1 days in jail in misdemeanors, but also none of that's covered under parole. Now, I know what you're thinking, enough waffling. You just want to know, when am I going to be eligible, or when is my loved one going to be eligible? So the general rule, and we're going to get into a lot of exceptions, but the general rule is that when your calendar time plus your good time credits equal 25% of your sentence, then you'll be eligible for parole. Now, we'll talk about what good time credits are in a minute, but just for now, imagine a 10-year sentence. When your good time plus your actual calendar days, those are the actual days you spend in jail, when those combined equal 25%, you'll have your first parole hearing. The biggest exception to this general rule is what's called 3G offenses. These are serious offenses such as, you can think murder, sexual assault, aggravated robbery, anything involving a deadly weapon finding, and that does catch a lot of charges that you wouldn't expect, but if there is that affirmative deadly weapon finding, it is considered a 3G offense. And the word 3G comes from where these offenses used to be listed. They were under the criminal code under 42A dot something 3G, and even though they've been moved now, it's a catchy name, so people still refer to them as 3G offenses. And if you hear that, you can just think serious offenses. And if you need to look them up, you can go to the criminal procedure section 42A.054 and just check that list and see if what you or your loved one is charged with falls under that list. And for these 3G offenses, you will not be eligible for parole until you've served half your sentence, and you don't get any good time credits either. So it's a significant difference there if you are charged with one of these 3G offenses. What are good time credits? How do you get them? How do you calculate them? So to separate them, let's just define what calendar days are versus good time credits. Calendar days are very simple. Each day in jail is a calendar day you spent in jail. One for one, there's really no difference there. Good time credits can be credits you're given for days in addition to those calendar days. So when you first show up in the jail, assuming you haven't had any disciplinary issues before you got there, you're going to be a class 1 inmate. That means you're going to get 20 days of good time credits for each 30 days you spend in jail. So for each month you spend, you'll get 50 days. Now, those good time credits can adjust up or down. They can go down to 0 if you get a disciplinary violation. They can go up to 35 days per month if you're given a job or if you participate in school. You're given that trustee status that we talked about in connection with misdemeanors. If you keep that job and you don't have any disciplinary actions against you, you're going to be getting 65 days credit for each day you spend in custody. And also keep in mind, good time credits do accrue when you're awaiting your trial. So you do get credits at a pace of 20 for every 30 days, unless there are some disciplinary violations, but most inmates do get 20 days credit for every 30 days while they're awaiting trial. These good time credits can be taken away from you if you get into a disciplinary action. They have to have a hearing for that, but that hearing, they don't have to bring in much evidence. It's very loosey-goosey with the rules. It doesn't exist, for example, under the rules of evidence that you would have in court, and they can take away those good time credits from you. If they take those away, you can never recover those. And as I mentioned before, good time credits don't accrue for anyone charged with those 3G offenses. So we're only talking about non-3G. And there are also some other exceptions. For example, if your offense happened in a drug-free zone and involved drugs, you won't get any good time credit. So make sure you discuss with your attorney and find out if you're getting those good credits or not. You'll definitely want to clarify that before you sign a plea or decide to go to trial. All right, next we're going to talk about something called discretionary mandatory supervision. And if you're confused by that name, if it sounds like an oxymoron to you, you're not alone. I thought the same thing. How can you have something that's discretionary and also mandatory? It makes no sense. But the reason for the name is that this used to be mandatory release, meaning once you met these requirements, you had to be released by parole. There wasn't a decision to be made. It was automatic. Well, they released some people who committed some significant crimes, and in 1995, 1996, the legislature changed the law, and so now, even though it's called mandatory release or mandatory supervision, it's not really mandatory. You still have to go through the parole hearing process. You are eligible for discretionary mandatory supervision when your good time plus your calendar time equals the full amount of your sentence. So in that example where someone was given a 10-year sentence, the good time credit plus the actual calendar days would have to equal the 10 full years. But when that happens, it kind of flips the equation that the parole board is looking at. Instead of having to make that affirmative finding that you must be released because you've met these requirements, the assumption now is that you will be released, and the parole board has to make an affirmative finding that you have not been rehabilitated. It's kind of a weird semantic argument, but it does have an effect. If you look at the statistics, right around 50% of people up for discretionary mandatory supervision are released, up from about 1 out of 3 when you're talking about regular parole. Another thing you might hear in connection with discretionary mandatory supervision is something called the projected release date. That is the date you are eligible for discretionary mandatory supervision, or DMS. And you'll hear projected release date, and again, people are going to make that connection. Oh, that's my release date. But really, you're just up for another hearing at that point. You're up for that discretionary mandatory supervision. And yes, your odds are more likely that you'll be released, but they can still decide to not release you at that projected release date. And in keeping with the theme, 3G offenses not eligible for discretionary mandatory supervision. One small but important detail in certain cases is something that came from a case called ex parte res laf. So people refer to them as res laf cases, or you have a res laf issue. So inmates who are up for discretionary mandatory supervision, you must have a 30-day notice that you have a hearing coming up. And that's just to give you time to prepare your packet to get ready for that parole hearing. If you don't have that 30-day notice, you actually have to be released. So imagine a situation where before you did a plea in court, you have enough back time to meet your projected release date. but you haven't gotten that 30-day notice because you haven't pled your case yet. What happens? Believe it or not, you're automatically released from jail. You don't go through the parole board. They've lost their jurisdiction. You go straight to parole without them having to decide that you get on parole. It is really like a get out of jail free card. And people talk about Retzlaff cases. They don't apply in a ton of spots, but when they do apply, you do get that release right away. Bottom line really is you want to think about these issues as you're pleading your case. Talk to your attorney, ask him to do that calculation. How much good time credit do I have? When will I be eligible for parole? When will I be eligible for a projected release date with discretionary mandatory supervision? And always keep in mind that those dates are all discretionary. Even if it says mandatory, you're not guaranteed a release, but you still do want to factor in parole dates when you're deciding whether to plea a case, take it to trial. These are just one more factor to consider when your life is on the line and you're having to make difficult decisions with a prosecutor or to take it to trial. Of course, none of this is legal advice. Again, parole is a very tricky issue, so talk to your lawyer. If you want a consultation on your parole issues, you can always call us or visit us at atx.legal.